Hello, my name is Ruth Carter, and I'm a licensed attorney in Arizona. And this is your question of the day. So, somebody asked me, they said, my trademark was rejected for possible consumer confusion. My question is, can I respond to the office action by submitting a completely different name for my company? Or do I have to start the process over with this new name? So, when you file a trademark application and the USPTO, US Patent and Trademark Office, says there's a problem, they send you what's called an office action to tell you about it, and then they give you 6 months to submit a response if you think they made the wrong decision, or if they've asked you to submit an additional specimen, maybe modify the phrasing of your goods and services, things like that. Or they can say, we're rejecting your application because of consumer confusion. You can still respond within 6 months and say, no, there's no confusion because X, Y, and Z. It sounds like this person's in a situation where they're saying, yeah, I agree, there probably is confusion. I'm not going to fight it. So they say, can I just modify my application and go for a new name without having to start the process over again? Sorry to tell you, that's not how it works. If you want to get a trademark for a different name, you have to submit an application from start, including another filing fee. So, given that you've already been through the process, partially once and seen what can happen if your desired trademark is too similar to somebody else's, I recommend you consult an attorney before you submit your next application to see how likely it is that there are other companies out there using a similar trademark as the one you want on similar goods and services. You can't always predict completely whether or not the examining attorney who reviews your application is going to say this is fine or no, we have a problem. But you can do some research to try to predict how the USPTO will react to your application. But I'm sorry to say, yes, you do have to start over from scratch. And because I hate seeing people throw their money away by filing for trademarks that they can't have, either because the trademark has been already claimed by somebody else on a similar product or service, or there are times when somebody's company name or product name just isn't trademarkable. It's either generic or descriptive, and they won't give a trademark for that. I've seen a lot of people in that situation where they just applied for a trademark that they were never going to get, and I feel bad for them, but that's how the USPTO works. If you want to try again, you have to submit a whole new application. So I hope that answers your question. Of course, watching this video does not create an attorney-client relationship with any viewer. It's merely legal information, not legal advice. If you need legal advice, please go hire somebody. That's all I have on this topic for now. I put out new content every week, so please subscribe to the channel. And until then, I will catch up with you later. Take care.